Thank you very much, Senator-elect. And I have to say I'm quite embarrassed by the idea that TV cameras might turn up and hear from me, but not to get your full address. Thank you, everybody, for having me here this morning. Before I say anything else first, I want to say that it's a great pleasure to accept the opportunity and the invitation of Senator-elect to come and speak at your national conference. It's not a secret, as has just been outlined, that I have had a past partisan loyalty, but like many of you, the very basis of my political engagement is the advancement of classical liberal approach to human rights and to preserve and protect the individual from the abuse of power of big government, and so we actually have much in common. Secondly, I need to clarify that I haven't actually taken up my position as Human Rights Commissioner. That's why I'm referred to as Human Rights Commissioner Designate. Equally, this is my first address, but I understand I will be doing so later this month. Of course, one of the reasons I couldn't possibly take it up before this conference was because otherwise I would be the first public official on the federal payroll to turn up and speak at an LDP conference, and I'm going to leave that to the Senator-elect once he takes office. Third, I pondered whether it was appropriate to come and speak at a national conference of a political party. As an incoming public official, I was wary of the appropriateness of speaking at a political party conference, but concluded that political parties are precisely where I might find people who are interested in human rights. It is not the sole place, of course, but certainly one of many of them. So my policy in this role will be to be open to speak at major political party conferences and events wherever I reasonably can, and that includes all political parties, including those whom perhaps some in this room may disagree with. But there will be conditions, that those are not to be fundraisers, and as has occurred today, the costs for my attendance are incurred by the party that wishes to host me. These costs will not be passed on to the taxpayer, and I think that that is a fair and reasonable way to conduct myself in public office. Finally, I accepted this opportunity today to speak to you because I want to broadly outline what I see as the broad goal of my 5-year term, as well as the broad challenges I think we face. I'm not going to delve much into specifics, and I hope people don't mind that. I know that President Whelan mentioned as I arrived today that the reason I flew in this morning rather than coming last night was because of the new lockout laws in New South Wales. But I had to break it to him that in fact my idea of a good Saturday night these days is staying at home, drinking a glass of red or white wine, watching Midsummer Murders, and promptly going to bed at about 9:30 with my partner. So it had nothing to do with the lockout laws, it had everything to do with simple reality. But that's why I'm not going to go into specifics, I'm going to leave those alone. From a human rights perspective, Australia, of course, is a unique country. As you all know, Australians have few instruments to protect a rights-based approach to limit the abuse of power of government. We have modest, explicit or implied rights within our constitution. We have a hodgepodge of state-based charters that do little to protect rights, but do at least prompt the Parliament and the bureaucrats to consider legislation and regulation from a rights-based perspective before taking the course of action they were always likely to take. Yet we also have common law protections and have ratified various treaties that claim to protect human rights, including from a natural rights perspective, while concurrently treating them not as rights, but merely worthy, inconsistent aspirations for the type of society we wish to live in. More often than not, Australia's political system is interpreted simply as a transplant of the Westminster system to the Antipodes. Yet any proper analysis cannot ignore the contribution of American political thought and its influence through the development of a federalist system, as well as an elected upper house, which you're all acutely aware of at the moment. So much of the British political tradition around rights is that it evolved out of a revolution to temper the abuses of feudalist and monarchical power. For America, it was the same, as well as in response to internal revolution between the states. What makes Australia unique is there's a fusion of these traditions that is also absent the protections afforded to Americans and the Brits, and it's up to us to protect our own rights. Australia was founded for any other purpose than to be evolutionary hybrid of the British and American tradition to found a liberal democratic society. Australia may only have been founded from administrative procedure, but is arguably the most revolutionary model of political governance of these comparable models to protect those rights. The expectations, the great bulwark to the abuse of government power is an active citizenry, and that is the custodian of all Australians to stand firm and proud in defence of their universal rights, and that failure to do so gives licence to the legislature to encroach on them. Rightly or wrongly, the ballot box is where we protect our rights rather than through a lot of other mechanisms. That's why I want to make it clear that the objective of my term as Human Rights Commissioner will be focused on how I can foster a culture of rights and responsibilities. The question I am now facing is, how do I go about that? Some argue that we should follow the US tradition and adopt a Bill of Rights. There are diverse views amongst the community, and no doubt amongst this audience. I confess my opinion actually remains quite open. I understand the criticism from all sides. I understand the argument that some people believe it is essential to temper the abuse of power of government by the Parliament and the Executive, especially when the Parliament, or at least the House of Representatives, is engaging with little independence from the Executive, though I'm quite confident that that plan may have been tempered somewhat by different voices coming into the Senate of late, including, of course, the Senator-elect who's in front of me. Similarly, others argue that if we get some form of bill or act of rights, it would be focused on expanding rights from limiting the abuse of power of government toward achieving all sorts of objectives, some of which are entirely desirable for society but are a different concept to rights, and to achieve at least one group's perception of a more just society and limit the exercise of those rights. In practice, that means that rather than unleashing the potential of a rights-based society that through a rights bill or act or charter, it could confirm and entrench the encroachment on exactly the protections we are seeking to prefer. Others argue that some of our rights charter will lead to gifting too much decision-making power to the judiciary. And that leads quickly to whether we have the political and judicial culture to ensure that the courts will defend rights against government objectives. As I have already outlined, my opinion remains open, but I'm tempered by a recognition of the reality of Australia's political traditions. I suspect most people in this room have robust views about human rights, the sacrosanct nature of private property, and I include in that ownership over our own bodies, lives and enterprise in that, as well as the importance of free speech, association, movement and worship. I suspect rhetorically most Australians share a very similar view. But when we get down to specifics, Australians have always been prepared to trade a certain dimension of their rights for pragmatism and security. Senator-elect, I confess that I was partially brought to this conclusion by one of your future colleagues. In 1985, Hugh Collins wrote about the political culture of Australia in his important article, Political Ideology in Australia, the Distinctiveness of a Benthamite Society. In his essay, he argued, Australia's perennial debates and predicaments may be understood. The differences presented to an American or British observer become comprehensible if one begins by regarding Australia as a Benthamite society. What is meant by a Benthamite society? Simply that the dominant ideology of this society conforms to the essential character of Jeremy Bentham's political philosophy. Three aspects of Bentham's thought are crucial here: his utilitarianism, his legalism, and his positivism. Each of these requires a brief discussion before demonstrating the tensions and tendencies within Bentham's philosophy. I won't go through all of those different discussions, but Collins continues arguing, Bentham's theory is equally hostile to doctrines of social contract. Although a theory of individual interests, it rejects the notion of natural rights, which was central in both the American and the French revolutions. Eli Helvey states Bentham's position succinctly, and he goes on to quote, governments were instituted not because man had rights, but because he had none. In an ideology faithful to Bentham's system, natural rights will be an alien tradition. The rationalist assumptions of Bentham's political philosophy signal an approach to politics that is both secular and instrumental. Here is no deistic basis for religious exceptionalism. Political institutions are human contrivances, not divinely ordained. The expectations are mundane and unheroic. There is neither messianic mission nor return to a classical ideal. Utility imposes its own discipline upon reality and sets its own limits to imagination. End quote. Before I say anything else, I can recommend to everybody in this room they go and read Collins's insights. Collins's essential argument is that while significant intellectual and political events have informed the development and the nature of Australian political tradition, in practice it operates on a largely pragmatic and legalistic basis. His article was written in the 1980s, but it does foresee how the adoption of more robust and principled political philosophies runs into practical tension with Australia's political tradition. And I have to say, I find Collins's argument and analysis quite convincing, though obviously it doesn't necessarily reflect the Australia as some may want it. It does broadly describe the Australia as it is and where it came from. Collins's analysis raises many serious questions for approaching human rights in Australia. For example, we have common law rights in theory, but in practice, so long as the legislature writes laws specifically enough, they can be trounced as politicians see fit. Yet the whole concept of rights is for them to be a nuisance for governments seeking to advance progressive causes. As many of you know, my background is actually in trade policy. As a proud and staunch free trader, I'm immensely proud of our country and what we have generally achieved in removing trade barriers. But the process of Australia achieving this unilateral task provides some insights of how we might go about fostering a culture of rights and responsibilities. In essence, Australia reformed its trade policy by removing barriers over a prolonged period of time by recognising the policy setting and operation was different from where it should be, and then designing a process for how to progressively structurally adjust the policy to go from where you are to where you want to be, and to do so in a way that took as many people with you for as long as possible along the journey. Learning from this experience, that raises the question of how can we create a culture that embraces a rights-based approach to protect the rights of the individual from the abusive power of government. And I suspect it's part of how we see ourselves. In fact, while we have a relatively utilitarian political tradition, some of the key moments in Australia's history have come directly as a response of encroachment of rights. There are, of course, many examples, but let me just give a few. The early 1800s Great Rebellion against Governor William Bligh, regularly dubbed the Rum Rebellion, is presented as a dispute between an autocratic governor and settlers. But it also highlights social contract, the rights of free people against the excessive abuse of government power, and how it is central to the legitimacy of those who seek to rule over us. The 1897 First Congress of Unions might be interpreted as a celebration of industrialised, organised labour, but is also a practical demonstration of the important role of free association in the colonies. Most people know of the 1854 Eureka Stockade as a miners' rebellion against imperial British forces, but of course it was also a tax rebellion against excessive levies imposed on individuals. Each of these key examples events are examples of a rights-infused culture, but they are rarely presented this way. The absence of this narrative is partly why I have been critical of how rights are presented in the national curriculum. Some of you may have recently read an article I had published in The Australian a few weeks ago, which argued, quote, "The national curriculum primarily introduces human rights under the banner of rights and freedoms in Year 10 history. While the title is broad, the approach is very narrow. According to the curriculum, human rights are approached as a post-1945 concept focusing on the origins and significance of the Universal Declaration of Human Rights, including Australia's involvement, which we shouldn't ignore was significant. It also focuses on the recent struggle for the rights and freedoms of Indigenous Australians and the US civil rights movement and its influence on Australia. Again, very much a post-war phenomenon. The point is not to argue that these significant events that I outlined earlier should be solely viewed through a culture of rights, but they are certainly parts of a rights narrative of Australia that didn't just evolve post-1945. Instead, these values were infused in the worldview and political culture that arrived with those that arrived on our shores not far from here 200-odd years ago. As former Howard government minister and avowed Liberal, or as would you call it, tax and spend party former minister, Dr. David Kemp, who's a good friend of mine and is a great man, in his essay, The Liberals, A Short History of Liberalism in Victoria and Australia, argued, liberal ideas came with the First Fleet and its successors and had been formulated by French, English and Scottish thinkers of the Enlightenment, such as Locke and his social contract, Montesquieu and the balanced constitution, Adam Smith, where he focused on private self-interest in the market and how it could serve the public good, and David Hume for reason was the best way to understand the world and decide on policy. As I argue in my chapter on Australian liberalism in the book I co-edited, Turning Left or Right, Values in Modern Politics, available for $35.95 from Concord Press, no one political party has a monopoly on liberalism and liberal ideas in Australia. All mainstream political parties have a dimension of liberal thought that informs their approach and their approach to politics and public policy. Obviously, there are varying degrees. It is only through that extent that we can weight those values and how they see them central in either practice or rhetoric that they approach their political engagement. While I know there's a temptation among some to call everyone less liberal than themselves as communists, let's face it, Australia is actually quite bereft of truly revolutionary political parties. Some mainstream parties have tendencies towards more radical dispositions, but they are rarely revolutionary. But the absence of a rights culture should not be treated with despondency. What it ensures is that the direction of Australia's rights culture is open to those that want to seize it in hearts and minds. And this is going to be part of the debate we are going to have this year. The Attorney-General, George Brandis, has already directed the Australian Law Reform Commission to investigate legislation that unnecessarily encroaches on traditional rights, freedoms and privileges, including reversing the onus of proof, procedural fairness, the right to not self-incriminate, free speech, religious faith, property rights, free association and movement, restricting access to courts, among others. In his announcement of the Cabinet decision that I will be nominated as Australia's next Human Rights Commissioner, he made it clear that I should focus on these rights as well. And clearly one of the first debates we are going to have is explicitly on free speech, and particularly the sensitive area of the Racial Discrimination Act. I have looked up the LDP's position and I know that it's pretty consistent with my worldview, which is that we should support almost total free speech. I have already outlined my concerns with Section 18C. The first is that it sets the bar far too low in restricting speech, that no longer really seems contentious. The idea that people can attract legal sanction for saying something that's insulting or offensive now actually seems to be widely accepted, even though it currently exists in law. But I argue that the terms humiliate or intimidate sets an equally low bar, and let me explain why. When looking at issues of race, we are often infusing issues of national and cultural identity, for the same reason that it is always difficult to know what insults or offends somebody from a different heritage. The same is also true of humiliate and intimidate. Worse, the current nature of law also creates distinct and subjective group rights. Let's use a very practical example. Person A comes from a particular racial background. Person B is homosexual. Person A verbally attacks person B on the basis that their homosexuality is offensive, repugnant and disgusting. Person B then responds with such comments, and they've been used relatively recently by some others, that often the most hostile people to homosexuals are closet homosexuals themselves. Both individuals might be insulted, offended, humiliated or intimidated, particularly if it's done in front of a large group or if it's done through some sort of media such as print, online or radio. They might be offended, insulted, intimidated or humiliated by each other's statements. But person B, the one who has been attacked because of their sexuality, has to wear it. Person A has recourse to the law on the basis of their racial identity. In short, that is unjust. In response to the previous federal government considered extending protections to different protected groups in the community under its earlier proposed Human Rights and Anti-Discrimination Bill. In practice, that just extends the unjust nature of these free speech protections to a broader number of groups. It doesn't address the unjust nature of the restriction. Only removing it can address the unjust nature of the limitations on free speech. Now, it's all well and good to argue that restrictions on free speech should be removed, but that should not be married with an indifference to some genuine concern about the risks of racial vilification. It happens, it exists, and it's important to address it. The question is how. I've made it clear that the limit should only be to the extent that speech conflicts with other human rights, notably when speech explicitly incites and provokes violence against others, because that's a clash of rights. But to successfully explain the merits of such an approach to the Australian public, it's important to remind everyone that even though the limits of the law may be far, that needn't mean the limits of acceptable speech should not be narrow. The debate surrounding free speech is about the extent there should be legal restrictions on what people can say and converse, not the bounds of socially acceptable conduct. But that must be explained to people so that people understand that they can bridge the divide between where the law is and where we would like it to be. But that voice is largely absent, and like you, I plan to fill some of that. Following his elevation to Australian of the Year, Adam Goodes announced he was keen to use his position to advance the noble cause of stamping out racism. According to Goodes, it is about, quote, educating people about what is acceptable, what isn't, to encourage people to talk about ways that we can actually have conversations to eliminate it, being racism, because they are going to be conversations with friends, with strangers, with family members. Goodes correctly identified that social and cultural norms play an enormous role in shaping acceptable conduct. Free speech doesn't mean speech without consequences. Even without compulsory laws, we voluntarily regulate speech for conduct such as inaccuracy. Let's start with an example very close to home. Late last year, the Attorney-General, as I've already said, announced the Cabinet's decision to appoint me as Human Rights Commissioner, with a specific focus on advancing traditional human rights such as free speech and association. One of the most persistent and inaccurate criticisms to my appointment was that I had allegedly previously stated that the Human Rights Commission should be abolished. A senior politician went so far as to say that, quote, Mr Wilson is already on the record calling for the Human Rights Commission to be abolished, end quote. That statement is incorrect. It is not often I quote Wikipedia, and I realise how controversial that can be considering its capacity to be edited, but in this case their Tim Wilson page currently, at least as of before I got up to this lectern, correctly states that, quote, while working for the Institute of Public Affairs, they, being the IPA, call for the Human Rights Commission to be abolished. Wilson has not made any personal statements to this effect, but it's widely attributed to him. It is a derelict to apportion that statement to my appointment as suggesting that all staff at the Human Rights Commission supported their 2013 submission to a Senate inquiry that stated, quote, the Commission does not oppose the removal of the Human Rights Commissioner position, end quote. Even when faced with inaccurate comments, the solution is not to silence the accuser. The solution is more speech. Inaccurate statements should be exposed so that the credibility of the individual who made them suffers and brings into doubt their reliability into the future. Norms needn't be informal. They also can be informal, as some former public servants are discovering at the moment. Many of us voluntarily sign up to codes of conduct as a condition of our employment. While these codes vary, they often include ensuring that employees rightly do not engage in offensive or harmful conduct, such as making sexist, racist or homophobic comments to others, or do not engage in public acts that may harm the organisation's reputation. Some people wrongly argue these formal conditions are a restriction on free speech. They are not. It is obviously not a desirable choice, but at any time an employee can resign because they no longer feel that they can honour the code that they have signed themselves to. And this doesn't just go in the public service. Of course, lots of people sign up to it in the private sector. The role of codes to regulate people's speech isn't just limited to traditional workplace environments. They're also common in civil society groups as a condition of membership, treating other people with respect, or participating in sporting groups. The Australian Football League requires that players must refrain from making any... Oh, that's a quote. The Australian Football League requires that, quote, players must refrain from making any comment that vilifies or tends to vilify persons on the basis of their race, religion, colour, sex, sexual orientation, or other related characteristics. It's pretty broad. The AFL, end quote. The AFL Players' Code of Conduct also includes processes for judging breaches and imposing fines and penalties that can be incurred. Formal codes are not the only mechanism to regulate speech. The marketplace can also send a very clear message. Fairfax newspaper sacked former columnist Catherine Devaney after she consistently tweeted distasteful and disturbing comments about celebrities and fallen Anzacs. Devaney's free speech was protected, but the newspaper rightly decided they no longer wanted to provide her with a platform or be associated with her conduct, and likely because of that damage it may cause to their brand and their commercial interests. Similarly, Tasmania's Marilla Winery also experienced the marketplace's regulation. The winery attached to David Walsh's Museum of Old and New Art produces wines to excite the senses. Marilla's 2010 vintage merged this philosophy with the labels on its wine. The labels included tantalising silhouettes of naked dancers splashing wine as an extension of their ballet routine. While unconventional, I suspect most Australians would probably consider the images artistic, provocative, but nonetheless tasteful. But when the bottles were sent to the United States, they received a very different reception. The at times prudish American market rejected the labels as being far too raunchy, and the vineyard eventually withdrew these labelled bottles. Marilla wines now carry more traditional labels, but Mona still sells a limited number of the controversial bottles directly to lucky customers, of which I own a case. For Marilla, even the high quality of their wine couldn't beat social norms on the limits of free speech. There should be a gap between socially acceptable conduct and legal limits on speech. We need people to be able to test the limits of social acceptability, to make us uncomfortable, and to ensure that unpleasant and challenging ideas are given a breath of fresh air, even if it's only so they can be challenged, responded to, and shot down. Compulsory legal limits on speech based on acceptable conduct can undermine human rights, whereas voluntary norms, codes and market signals informally regulate speech and can be far more effective both in the immediacy but in driving changes towards civilising acceptable behaviour. That is the very nature of liberalism, that through voluntary engagement by free people, it can have a civilising effect through interaction, community engagement and enterprise, and often without the need for arbitrary and restrictive laws. I suspect most people in this room understand these basic concepts. I suspect instinctively so do many Australians. But that needn't mean some need to be reminded to help bridge the divide between Australian pragmatism and the development of a rights-based culture. Thank you.